companies now have a better expectation of how they are going to play out and what their liability is likely to be in the future. So, companies can deal with extra costs. What they don't like is they don't like ambiguity or unpredictability. And so I think this decision adds perhaps a little bit more predictability after we resolve the whole reimbursement or repayment of the tariffs. My name is Dan Cahoy. I'm a professor of business law at the Smeal College of Business. I'm also the department head for the risk management department. The people that laid out money initially are what we call the importers. So those are the ones who have the standing to get back the money that they paid to the government. And so what we're looking for is that process is a process by which they make an initial payment and there's eventually a determination of whether that payment is correct. So at this point, they're waiting on some of these tariffs to see whether or not the government will agree that those tariffs were improperly collected and just give back the money. Essentially, what importers are looking at, the complexity of this, is a determination of to what extent the government will willingly provide money that it's well been established now that the Supreme Court was improperly collected, or whether companies will have to secure the right to that money through a lawsuit in a court called the Court of International Trade. I guess where this becomes a real problem is there are certainly more expenses associated with being compelled to sue, and it's probably going to fall harder on smaller companies than it is larger companies. And to be clear, this is not a prospective process. Many large companies have already sued in the Court of International Trade to secure their right for refunds whenever the Court of International Trade gets around to providing the procedure for delineating all these claims. And let's be clear, we're talking probably 300,000 companies have been involved in IEEPA tariffs, and we're talking about $175 billion in collected tariffs that are going to have to be paid back. In fact, it's quite likely that when you consider the expenses that some smaller companies will decide it's not worth it. It's true that the largest companies have paid the largest share of the tariffs, and it makes sense for them. Their bottom line could be in the billions for an individual company like a Walmart. So of course it's worth it for them to go through the process, even if it is relatively expensive. But yeah, for a small company, they might say, this makes no sense for us to spend the filing fee for the Court of International Trade and perhaps hiring an expensive trade attorney to get back a few thousand, maybe even $100,000 in tariffs by the time it's all done, which could take over a year. It might not be worth it. On Monday, the Court of Appeals for the Federal Circuit, that's the intermediate court before the Court of International Trade and between them and the Supreme Court, decided they weren't going to delay the case any longer and send it back down to the Court of International Trade. So that basically just keeps the process moving and ensures that the maximum allowed time to review the case before it goes to the next level wasn't taken. So, I think what it does is just reduces delay. It doesn't change the outcome. It doesn't make it any more or less likely that a company is going to get their tariff refund, but it does reduce perhaps the time this will take place. There have been cases in the past, not very many, but there have been cases in the past where there have been broad rulings invalidating tariffs across the board for a number of companies. One large one was, I can recall, in 1998, the Supreme Court invalidated a harbor tax, which is essentially an unconstitutional export tax. And there was something like $700 million in refunds that had to be paid to 3,000 companies. That's pretty different in terms of scale, but it is a number of companies at once. They were all required to file claims. So there is a precedent for large-scale tariff refund, but nothing of this scale involving this many companies. I've heard that some of the members of the administration have floated the idea that perhaps they could say a company or an importer maybe doesn't have standing to pursue a claim if they pass the costs downstream, if they pass the tariff off on the companies and the consumers who ended up paying it. I think that's very unlikely. They've never required that kind of showing in the past that you actually have taken on the cost of the tariff entirely yourself. So I think that's unlikely. The tariff is an invalid or at least this particular tariff, was an invalid acquisition of duties. And so I don't think there's any real argument that the government can hold on to it. There won't be much of an impact in the immediate future because the administration has imposed a sort of replacement tariff power under what's called Section 122 of the Tariff Act of 1974. And Section 122, it's not a perfect fit. It allows the president to impose tariffs of up to 15% based on what's called a balance of payments deficit. And you can find a coterie of economists who will explain that that is not what's actually going on right now. It's not the same as a trade deficit. But regardless, it still might be hard to win that argument in court because there are other ways of looking at it. And currently, almost immediately, within a day, I should say, the administration imposed a 10% across the board tariff on most of the goods that were tariffed under IEEPA. So it replaced a substantial part of it.